begin first by thanking you all for being here today on what is absolutely, for this office, for the community, and our criminal justice system, a historic day. In the early morning hours on May 2nd, 1976, Nathan Myers and his uncle, Clifford Williams, were arrested for allegedly having just committed murder. The crime was shocking. Two women asleep in their bed were ambushed. Nina Marshall survived, Jeannette Williams did not. Shortly after being shot, Miss Marshall indicated Nathan Myers and Clifford Williams as the shooters. Nathan Myers and Clifford Williams were at the scene that morning, among many other people who had convened from a nearby party upon hearing the shots. Both men were arrested, standing outside of the crime scene, among the very same friends with whom they would immediately explain had been with them at the time of the shooting. Upon being arrested, both Mr. Myers and Mr. Williams denied shooting anyone. Separately and independent of one another, both told police the same story, that they had just been at a nearby party when the shots rang out, and that they had multiple witnesses who would confirm just that. 2 months after their arrest, they were tried. Each faced the death penalty. Before trial, then 18-year-old Mr. Myers was offered just a few years in prison in exchange for a plea of guilty. Even though he was facing the death penalty, Mr. Myers refused the offer, explaining then and maintaining still today that he could not plead guilty to a crime he did not commit. He instead placed his trust in our system. Both men were convicted. Mr. Myers was sentenced to life in prison. Mr. Williams was sentenced to death. From the first moments when they were taken into custody almost 43 years ago until today, both men have professed their innocence, and since their convictions, each have steadfastly maintained their innocence. And over the course of 4 decades, each have sought post-conviction relief, and today they were granted that relief. As prosecutors, we have a continuing post-conviction ethical obligation to pursue justice when we become aware of material evidence suggesting a conviction is not correct. Acknowledging this obligation and rooted in our ethical obligations to put justice above all else, we created the first conviction integrity unit in the state of Florida in January 2018. This conviction integrity unit is charged with investigating and resolving plausible claims of actual innocence. The CIR has no desire to lend aid to the guilty, but will thoroughly review claims of actual innocence. The unit has established rigorous criteria before deeming a case worthy for review, and only those claims that are capable of being substantiated by credible factual information or cases where evidence previously not considered by the original finder of fact can meet the standard for acceptance into the unit. Every day, the over 100 prosecutors in this circuit seek to do justice in our criminal courtrooms, and the purpose of the Conviction Integrity Unit is to retrospectively pursue the very same objective. When we created this unit, we did not know where this endeavor would lead or to what cases it would actually direct us. The effort brings us here today. In January of 2017, after reading about our office's interest in creating a Conviction Integrity Unit, Mr. Myers sent a letter to our office. He told us that he was innocent of having committed the crimes for which he was convicted in 1976, and he requested that we review his case. His letter sat for a year, because at that time, the Conviction Integrity Unit was still just an idea. A year later, when the unit became operational, Mr. Myers' letter was one of almost 100 petitions awaiting the newly hired Conviction Integrity Review Director, Shelley Thibodeau. His letter caught her attention for several reasons. His letter asserted claims that could be tested and, if substantiated, would support his claim of innocence. In essence, his petition met the criteria and the requirements for the unit's consideration. More specifically, he explained that the jury in 1976 never heard from any of the people who could and would have testified then, and had indeed confirmed since that he and his uncle, Mr. Williams, were at a party when the shots rang out. That the jury did not know about the undeniable physical evidence that directly conflicted with victim witnesses' description of how the shooting happened. And that years later, after the trial, another man had confessed to several of his friends and family that he, not they, had committed this murder. The Conviction Integrity Review accepted review of this case. Ms. Thibodeau reviewed the investigative record. She reviewed the entire trial, appellate, and post-conviction record in this case. She read every report, every transcript, every statement, and every pleading filed by Mr. Myers and Mr. Williams over the last 4 decades. And then her team went about determining whether Mr. Myers and Mr. Williams' claims of innocence could be substantiated or not. She sought to speak with every single potential witness in the matter who may have any relevant information about what happened on that fateful morning almost 43 years ago. And while many people have died over the last 40 years, many people with very important information to share are still living. Finding them was challenging. Talking with them was not. She tested their memories and their statements to determine if they could be coerced. She approached them in a way to guard against or ferret out any sense of orchestration or coordination. Refusing to advance her own theories of how the shooting unfolded, she then sought expert opinions from a crime scene reconstructionist, a ballistics expert, and our circuit's chief medical examiner. She learned that the forensic evidence was in direct conflict with the explanation of events as described by Miss Marshall. She conducted experiments to test the reliability of the statements of both Miss Marshall and the alibi witnesses. She and her team studied in excruciating detail the description of every entrance and exit wound, every crime scene photograph, every investigative report in order to determine the origin from where the shots were fired and the bullet trajectory of every shot. With the assistance of our forensic artist, Jim McMillan, and crime scene reconstructionist, Tom Brady, the team recreated a virtual computer model of the actual crime scene in order to determine how, in fact, the shooting had occurred. And finally, she asked that both Mr. Myers and Mr. Williams submit to polygraph examinations administered by a Jacksonville Sheriff's Office polygrapher. And both men readily agreed. This investigation and re-examination took over 10 months. Fact-driven and frankly skeptical, it left no stone unturned. The Conviction Integrity Unit is deliberately structured in order to be independent from the rest of the State Attorney's Office, and for this reason, it reports directly to me. So week after week, I would meet with Shelley, and update after update, the investigation continued to confirm those claims made by Mr. Myers in his letter. And when it became clear that the conviction could not be supported by the record or the evidence, the Conviction Integrity Review Unit ultimately concluded that the conviction of Mr. Williams and Mr. Myers should not stand. Ms. Thibodeau presented the investigative report and investigative findings to an independent audit board this past February. This independent audit board was developed to function as a critical and discriminating backstop of her work. The board is purposely comprised of a group of people with relevant experience in criminal investigations, prosecution, law enforcement, and criminal defense. A former prosecutor and partner with Paget & Paget, Ray Reed, sits on that board. The retired special agent in charge of the FBI Jacksonville Division, Jim Casey, sat on this board. Former prosecutor and current assistant general counsel for the city of Jacksonville, John Phillips, sat on this board. Our circuit's former elected public defender, Bill White, sat on this board. And community member at large, Florida Blues North Florida Market President Darnell Smith participated as well. This group, after reviewing the Conviction Integrity Review's investigation, the IAB specifically determined that Mr. Myers and Mr. Williams have presented claims of actual innocence that are corroborated and substantiated by credible evidence. That these men would not be convicted by a jury if the jury were presented with all the exculpatory evidence that the original jury did not hear. I agree. The culmination of all of the evidence, most of which the jury in 1976 never knew about, leads us to my decision, our actions this afternoon in court, and this announcement. So today, after the granting of both men's post-conviction motions, the state of Florida has dismissed the indictments against both Mr. Williams and Mr. Myers. I'm going to ask you to be patient as I go through my thanks for many people who made today possible. The first are those who, without them, we would never have realized the Conviction Integrity Review Unit at all. And the first is Hank Cox and the Bedell firm, Buddy Schultz and the Holland and Knight firm, and Nina Morrison with the Innocence Project. If not for Hank and Buddy, this unit would not be a reality. In the fall of 2016, Hank and Buddy hosted Nina Morrison at the Bedell firm to discuss with us how we would go about actually setting up a conviction integrity unit. Hank was instrumental in the formation of this unit and actually in the development of the procedures by which it abides. Ben Carnark, the Florida Times Union journalist who posed a question to me that prompted a headline and a story. And that question and that story gave rise to our partnership with an academic partner, was the impetus for Mr. Myers' letter, and importantly, the stimulus that initiated our subsequent effort to present an idea to our devoted lawmakers in Tallahassee to make this idea a reality. To John Holloway of the Quattrone Center, our academic partner at Penn Law School. He is the executive director of the Quattrone Center for the Fair Administration of Justice. He consulted with us on how to set up this unit consistent with best practices around the country and the best thinking in the space. To our lawmakers who believed in the value of such an endeavor as this, Senator Aaron Bean and Representative Clay Yarborough together sponsored the legislation that funded the Conviction Integrity Unit. Our local delegation, Representatives Ford Burr, Tracy Davis, Jason Fisher, Leader Audrey Gibson, and former Representative Jay Fant. Special recognition to Chairman Rob Bradley and Chairman Travis Cummings for helping get this appropriation through the Legislative Budget Conference. And to our friend Speaker-designee Chris Sprouse, Ambassador Carlos Trujillo, former Speaker and now Commissioner Richard Corcoran, Congressman Greg Steube, and Senator Jeff Brandes, all of whom met with us and supported this concept. This work is important certainly to Mr. Myers and Mr. Williams and their families who are here today, but it's important to the criminal justice system and to our community. The next are those I'd like to thank who are responsible and specifically making today happen. Seth Williams and Krista Dolan with the Innocence Project and their team for their representation of Mr. Myers. Buddy Schultz and Holland and Knight for his representation of Mr. Williams. Operation New Hope, Kevin Gay, Linda Joseph, and their staff for preparing these men for transition into regular life. To our panel members, Ray Reed, Darnell Smith, Bill White, John Phillips, and Jim Casey, who shared their time, wisdom, and intellect with us. To the Jacksonville Sheriff's Office, Sheriff Mike Williams, Director Tammy Morris and her team, Major Steve Weintraub and his. Thank you for working so well with us today to ensure transition, an easy and seamless transition and processing for these two men. To Circuit Court Judge Angela Cox. Her thorough pronouncement today of her findings confirmed what we described yesterday to these men about the judge before whom they would appear. Bold, bright, fearless, and prepared. Mr. Myers started crying yesterday when we described Judge Cox to him. And to my team and colleagues, Shelley Thibodeau, Tom Brady, Emily Jones, and Jim McMillan, your tireless, tenacious, and exhaustive investigation is something that I've been inspired by and am proud of. They challenged each other with hard questions and went about ensuring that their conclusions were evidence-based and fact-driven. I'm proud to work with you, with each of you, and proud of your work. Importantly, to the family of Jeannette Williams. For family, news such as this can be difficult news to comprehend. Her sisters have been incredibly gracious to our office. Jeanette's sister Joyce still carries her 1976 ID card. We appreciate their graciousness to us and their willingness to hear about our investigative findings. So as you have heard, we took our time, and that time, every question, every meeting, every draft, and every discussion about this case was another day and another night that each of you remained incarcerated. So lastly, to you, Nathan, and to you, Clifford, thank you for your patience as we went about our work. But as we took our time, as we do in all of our pending cases, we did so to ensure you could have full confidence in what we have done. And that has meant this. It's not enough for me to stand here today and tell you what we have done, but for you to be able to independently assess our investigation. And the investigation, the culmination, is outlined carefully in a 70-plus page report that is publicly available to all of you. And the reason that I'm not taking time here to go through the details is because they are chronicled in great, great detail in that very comprehensive report. Finally, there are two main errors our criminal justice system can make. That is failing to hold the guilty accountable and convicting the innocent. One of those errors has forever been thought by our society to be far worse than the other. When we have the opportunity to correct these errors as a system and as a society, we agree we should do so. For prosecutors to do anything less reduces public confidence in our system. Human systems will always be plagued with human error. What we do when confronted with those errors, we hope will be the standard by which this office will be judged. Until this afternoon, both of these men were serving life in prison, and indeed Mr. Williams had spent 4 years on death row. Today, both men have been released, and tomorrow, both will be free men. The Conviction Integrity Unit functioned just as we envisioned when it was created. The first duty of our society is justice, and today that has been achieved. Mr. Myers or Mr. Williams, would either of you like to say anything?
Yes. Good afternoon. First of all, I'd like to thank my Lord and Savior Jesus Christ for putting these two people in my life here. Because they was there for me when I needed help. Everybody else had their plugs in their ear, they wouldn't listen. You know, my grandfather and grandmother always told me, you got 2 ears and you got a mouth, 1 mouth. Close your mouth and listen. So if you don't listen, you'll never know nothing. So I tried, years and years and years. You know, I wrote all the Innocence Project. I wrote lawyers. They wouldn't listen. They told me my case was too old. They didn't have the evidence to free us. A friend of mine, Tony Brown, reading the newspaper, seeing their unit in the paper. He said, you need to read this paper. I read the paper. That's how I contacted them. The Thibodeau answered me back. She told me, Mr. Myers, we haven't started the program yet. She said, but as soon as I get it up, I'll get back with you. But I didn't wait. I went to send her paperwork. All my paperwork I had that was denied. She told me I'm gonna make a file for you. And she did. When she called me, she gave me a phone call. She told me, listen, I want you to be truthful with me. If you tell me a lie, I'm out of there. I'm gone. So you got to be truthful. And I told her, it's not a lie. What I got to tell you is the truth. You know? And I believed in her and I trusted in her. And I think she fought real hard for me and my uncle, Clifford. You know, I always have respect people, but she's one woman I respect. But she did a good job. And Miss Melissa, her boss lady, you know, and she was right on with it. So I just sit back and let them do their work. Here's the outcome of it, you know. I give all my praise to Jesus Christ. Because if it weren't for them, for putting them in my life, I'd still be sitting in Sumter County right now today. Because no one listened to me. So I look at it as a blessing. I would never tell my uncle what I was doing. He found out until he heard from Miss Thibodeau. He didn't know what I was doing. When he found out, he was happy. Everything turned out good. Right now today, I'm able to go back to my family, and I'm happy. You know, I thank everybody who was involved in this here.
Yes.
You know, that's about it. Thank you.
Hi everyone, my name is Seth Miller. I'm the Executive Director of the Innocence Project of Florida, and along with Staff Attorney from the Innocence Project of Florida, Krista Dolan, we had the honor and the privilege to represent Mr. Myers in this proceeding. we've been doing this work for over 15 years at Innocence Project of Florida, and it usually doesn't go like this. We have to spend many, many years fighting and fighting and fighting to have moments like these. And this model that was used in this case is a breath of fresh air. Everyone who's sitting up here today was hyper-focused on doing justice and finding the truth. And this model, this conviction integrity revolution that is occurring across the country, was started by Ms. Nelson in the state of Florida, has been picked up in other places, is a new wave of how to do this work, where the state, with all of their resources and the ability to find things that we as defense attorneys can't even get our hands on, to find the truth, can really push these cases further towards the finish line in a quicker fashion, and to do it in a collaborative way between all the state actors, defense attorneys, the prosecutor's office, sheriffs, the court, is really the best way to do this work. And I think the beauty of this case is that it validates Ms. Nelson's vision that she laid out in her campaign when she ran and after she became the state attorney, and then she had the great wisdom to hire Shelley Thibodeau to do this work. And you know, when we got Shelley's report, we were, damn, this is a good report. This is thorough and diligent and no stone left unturned. And when Shelley asked us to come in and asked Mr. Schultz to come in to represent Mr. Williams, and we had to now produce something for the court, our work was made easier because of Shelley's 10 months of hard, persistent, diligent, thorough work on this case that really gave us a guide of how we could present this to the court. And so we are lucky and privileged and honored to have met Mr. Myers and Mr. Williams, and we'll continue to work with certainly Mr. Myers and hopefully Mr. Williams as they transition from a life in prison back to freedom. But we would not be here today without the great work of the State Attorney's Office, and particularly Shelley Thibodeau of the Conviction and Integrity Review Division. And it is just really an honor and a privilege to be involved here today, and so thank you very much.
I'll be very quick because my part in this is, as Seth just briefly described, is very, very minimal. But I cannot emphasize enough the significance of what I have been able to observe and learn over the last few weeks. All of us in our profession of law have standards and ethics by which we are to live and practice. Unfortunately, not all of us adhere to those ethics and standards. What I have had the opportunity to witness is the paramount adherence to the standards of not only our profession, but of our community, of our lives. Very simply, if you read the American Bar Association's ethical standards relating to prosecutors, it simply says the primary duty of a prosecutor is to seek justice. Folks, if you don't know Melissa Nelson, get to know her, because she not only lives that standard, she lives every other ethical standard that we can imagine. What she has implemented here is something all of us should take pride in and be grateful for. And not only does she have the good sense to do what she's done, but she has, I guess, had the better sense to surround herself with just some wonderful, expert people. What Shelley Thibodeau has done is a standard for all of us who go about representing people in our courts, in our society. Emily, Tim, Jim, Tom, and many, many others have helped her, not only with their hands-on, but I can't imagine the conversations that have gone on in the halls, on emails, at 2 in the morning. It's just something that all of us I suggest to you should take pride in. And it happened here in our community, Jacksonville, Florida, Duval County, 4th Circuit Court of Appeal, because of Melissa Nelson. Thank you. I'll close with just one anecdote. I said I was going to be quick. It's hard to do. Part of my good fortune was having the opportunity to go to Cross City to meet with our client, Clifford Williams. He walked in prison garb, in handcuffs. He shook my hand. He had this broad smile that he has on today. That is Clifford Williams. I told him why I was there. I was there at the direction of Melissa Nelson and Shelley Tipton. And I explained to him very briefly why I had been asked to come see him. He cried for 10 minutes. Then he laughed for about 10 minutes. It was a joke. And then he said, "Excuse me, Mr. Buddy, I hope you don't mind, but I have to go to the chapel." And thank God. And I think we all thank God for what we have witnessed and experienced here today. Thank you all very much.
So we'll take, I know that some of you have questions.
Melissa, does this exonerate the two?
So Jim, the IAB found that there was no longer confidence, in the conviction or the guilt of either of these men in light of substantial evidence of their innocence.
Does this also say something about the way that the prosecution handled the case and the defense? Were they ignored at that time, and this case was just really overlooked?
So what I can tell you is that things are very different today in 2019 than in 1976. Obviously, what we intend to do with this case after we are complete, one of the other functions of the conviction integrity review is to look back to see what are the lessons that we can take away and learn from in this case. But I would just tell you that things are different today.
How many other people have asked to have their case looked at?
So I think there have been a total of 200 petitions received to date by the conviction integrity review. And as I mentioned before, we've established very rigorous criteria for review. So Shelley reviews those petitions to determine if in fact they meet criteria or eligibility. If they don't, she sends a letter explaining that the petition does not meet criteria. And if there's something in it that perhaps she needs more information, she'll send a letter back asking for more information. And if, as in the case of Mr. Myers' letter, she had sufficient evidence to open a review, a re-examination, she does that.
Melissa, other than granting the sentence, what can be done to make these men whole for the 40 years that they lost?
So I don't want to speak to their intentions moving forward, but there is a statute, as you know, that provides for they would have to file for a petition to seek compensation from the state, and that may be their intent.
And Melissa, with
But
that,
I would just say, I mean, as we discussed yesterday, obviously money is material and does not restore what they've lost.
with that, obviously, Mr. Myers qualifies under that statute. Mr. Williams doesn't. Would you ask the legislature, given your experience going through this, that they change the qualifications under the wrongful conviction and compensation statute?
So I'm not prepared to answer that right now, but I will get back with you, Andrew, on that question.
This case went through appeals. Was it surprising as we learned more and more through this review process that the appeals upheld along the way?
So obviously, both of these cases went through the appellate pipeline and the post-conviction pipeline. And I'll tell you, the beauty of the concept of conviction integrity is this. One of the criteria is that all the appeals and post-conviction litigation be final before Shelley, the Conviction Integrity Review Unit, would accept a case for re-examination. And that's for an important reason. But the good thing about the unit is that Shelley can work collaboratively. So our post-conviction and our appellate units are set up to work adversarially. Those lawyers are, they're here to defend and protect the convictions of the state. Now, what we have established is that in the case where a newly discovered evidence claim is made to the post-conviction unit, that unit can refer cases for investigation to Shelley's unit. But the beauty of the conviction integrity unit is that it's not set up to work adversarially to the petitioner, but actually in a collaborative way, so that Shelley can reach out to them and ask them for more information. And I think that's why this took a long time, but it was still, overall, it was a fairly expeditious investigation.
Nathan, I know people want to know, what are you going to do now? I mean, what's the first thing you and Clifford wanted to do?
Well, the first thing I want to do is get with my family. That's the first thing. You know, and
Would you mind stepping up to the microphone? It's what a lot of people are interested in. They're just happy to see that you're out.
well, the first thing I want to do is get with my family. You know, and try to pull it back together, make it stronger. You said that it was without me. You know, because I have a very strong family tie. You know, I believe in that strength in the family. And I believe it'd be like it without me. And I believe I can pull it together. You know, that's what I want to do, the first thing. Everything else is second. You know, however it falls. I'm capable and able to handle it. You know, I just want to live my life peacefully and lovingly. That's all I want to do. Thank you.
Thank you.
Okay, thank you all for being with us today and coming here, taking time to listen to all of us speak and ask your questions. And we will be obviously available as you continue to have questions, as you look at our report. Certainly we'll be available through David to answer your questions. Thank you.
Thanks, guys.